Got a question on TikTok about if a landlord could kick or evict someone out of their home basically for having someone that's not listed on the lease. Hi, my name is Rob Wells. I'm the Landlord War on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, a lot of leases or rental agreements have like the listed tenants and authorized residents that can reside on the property. Okay, the tenants would be the ones that are financially responsible for the lease, but many leases also state how, other persons that are authorized residents, they're not financially responsible for the lease, but they're allowed to live there, such as, a tenant's minor children. There might be an adult like family member that's living with the tenant, etc. Okay, and in theory, hypothetically, yeah, if the landlord finds out that there's a completely different list of people on the lease agreement, basically, or someone that's not listed on the lease is living with the tenant, basically, that might be grounds for a 3-day notice to perform lease or covenants to be issued to the tenant, advising the tenant, hey, listen, the only authorized occupants or residents are listed on the lease. This person's not authorized to live here, so they're gonna have to leave, and so forth. They can't live here. Okay, that's a possibility. Landlords should be very careful, though, depending on the type of person who's living there. If it's like a family member, or I've had tenants have new children, basically newborns, and the landlord's asking me, the baby's not on the lease. You got to be very careful because there's called discrimination, fair housing, and both at the federal and California levels as well too. You have to look at these issues distinctly on a case by case basis, because if you try to enforce that provision, you could run aground a discrimination complaint from a tenant here. So counsel should be consulted with when you're looking at doing these issues. Many times, though, the solutions I tell landlords in most cases is, if there is an occupant that's unaware, that the landlord's not aware about, landlord would probably, in many cases, have the right to basically know the identity of that person living there, getting their identification and so forth for the landlord's records, and then adding them on as an authorized resident with an acknowledgement that the tenant, hey, he's going to be still financially responsible for anything that occupant does, etc. Okay. It just depends. And this is quite different from you find out that, hey, someone has, the tenant has moved out and then placed new people in. That's like a sublet or an assignment of lease, and many leases prohibit that outright, and that can be terminated immediately with a 3-day notice to quit. But you got to tread lightly in these scenarios depending on who it is and so forth, because you don't want the tenants to bring up any legal issues regarding that. So if you're in the Northern California area and you're facing this situation, feel free to reach out. We might be able to help out. Put your comments, questions down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.